How'd you know that? So it is Homer Plessy. And, you know, we were just talking earlier about hypodescent. This is Homer Plessy's genealogy. Way, way, way up in the, I think it's the upper right-hand corner, there's a black person. Way, way up there. And everybody else in his lineage is legally white, right? This genealogy actually raises one of the questions that Homer was trying to make. He actually made two different arguments, but we only know the case for the second argument. The first argument was that this particular system of hypodescent in and of itself was a racial injury. So namely, he obviously has a lot more white blood in him than black. But that preponderance of white blood does not save him from being categorized as black. It's an asymmetrical racial system, right? So you can't find somebody who has the opposite and basically say they're white. If he had been, if all these other ancestors had been black and he had one great-great-grandmother, he wouldn't have been defined as white. So he's saying that there's an asymmetry in the racial system that has deprived him of something valuable. And that thing he's been deprived of is whiteness, right? So that was case number one. Argument number two was, however we are defined by race, to segregate people on the basis of this classification denies those who are defined as black of equal protection of the law. So, now, the response to the first argument was, but you are not white. So because you're not white, you don't have standing to make the argument that you've not been defined as white, right? So essentially it's a circular argument. You can't make that argument because you don't have the standing to make that argument because the actual law has already defined you as not being white. So it's basically the court's refusal to engage in it. Now, I often ask people, if fairy godmother from the past comes forward and says, Homer Plessy, I'm going to bless you with one of your arguments. You just have to decide which one you want to win. You can either win the idea that the racial structure is itself asymmetrical and racist, so that you and people like you can actually make a claim for whiteness that the law will back up. Or do you want to win on the question of whatever the racial classification system is to create racial segregation in this particular social order is unequal under the 14th Amendment? And we have great debates about this because a lot of people say, well, if you show the inherent asymmetry of the racial structure, then that is a fundamental blow to racism. So we should pull that one out, right? And other people say, well, not necessarily, because there will still be people who are preponderance of the evidence would be black, and they will still be subject to racial segregation. And it's interesting, over the course of the years, we should dismantle the racial system line has won out over the however people are defined, we should not have segregation, largely because I think people buy the argument that the problem of race is acknowledging race, the problem of race is the one drop of blood rule, so if we just pull that string, it'll all unravel. And I simply say at the end, let us talk about Brazil. If we really think that removing, the juridical category of blackness or providing for greater fluidity in a racial system is actually going to eliminate racism. But I'll just talk about that afterwards if folks want to go there. The Plessy court ultimately decided that segregation was constitutional, but did it on a very curious argument. They said, it is true that the 14th Amendment did create the right to symmetrical treatment, and it created that right of symmetrical treatment as a right to civil equality. It did not create a right to social equality. So the question is, which side of the line did segregation fall on? Right? How do you know whether or not segregation actually violates the promise of civil equality or not? Well, the court said, look, if everyone is treated the same, then we have civil equality. Now, one might think, good, Plessy's going to win, because obviously you're not being treated the same if you're being forced to sit in a dirty, noisy, nasty car because you're black, but if you are white, you could sit in a better car. Not so quickly. The court said, of course everybody is treated the same. They're treated the same because they're being treated symmetrically. Whites can't sit in black cars, blacks can't sit in white cars. There's an equality in that, right? That's symmetrical. So all the state of Louisiana had to do was show, yes, we don't allow blacks to sit in white cars. We don't allow whites to sit in black cars. The court's good, got you, you're okay. Now, we all, by 20th century lights, look at that and say, how can anyone think that's symmetrical treatment when we know what segregation was actually about? It was all about the asymmetry of the message, the asymmetry of the experience, the symbol of it, the consequences of it. There were all these asymmetries that had everything to do with defining what segregation was about. So what did the court do with those asymmetries? They put them in the social realm. You can't do anything about those asymmetries. They're all social, right? So people are choosing to interpret segregation in a certain way. The court said, look, we're white. If the blacks take over the legislature and they create segregation, we certainly wouldn't feel that we are inferior because of it. So you should just choose to think differently. Right? If you think differently, you have your solution. Like click your heels 3 times and you'll be in, you know, the racial promised land. The second thing the court said was, look, if we give Plessy this right to social equality, we're actually giving the group something they don't deserve. And that would create all kinds of problems. So what we have to do is just stand back and let the whole thing work itself out in the racial marketplace. Eventually, African Americans might show themselves to be worthy. Eventually, they might be able to pull themselves up by their bootstraps. But we can't give it to them because that would be giving them preferential treatment.
Good morning, good evening, and good afternoon, Africans. I hope you're doing fine where you are, and if you ain't doing fine, please do fine where you are. I have something to share with you today. There is an African proverb that goes, when the spider webs join together, it can tie up a lion. You know how weak a single strand of a web is, or that of a spider is. Now, if you bring them together, it's strong enough to tie up a lion. And the lion is a very massive animal and very strong. So that tells you the importance of togetherness. That tells you the importance of collectiveness, or rather a collective mindset, as opposed to an individual or individualistic mindset. So this proverb teaches that when small things join together, or when small things join forces, they can face even the biggest of problems. In the same way, when we understand how different kinds of unfairness connect, we can fight them better. This is what a black American teacher, professor by the name Kimberly Crenshaw talks about when she speaks about intersectionality. So Kimberly Crenshaw, who is a black American teacher, explains how race, gender, and inequality are not separate problems. They overlap and affect people in powerful ways, especially the black women in America. So Kimberly Crenshaw is a law professor and a civil rights thinker. In her famous speech, The Urgency of Intersectionality, she told the story of how black people are often invisible in both the fight against racism and the fight for women's rights. When people talk about racism, they often focus on black men. When they talk about sexism, they often focus on the white women. Black women who face both at the same time are often left out in the picture. Asking her audience to name the names of black women killed by police. A very good question. I'm going to stop it here. I want us to listen to Crenshaw's speech, listen to how she narrates these problems, listen to how she tells the story of intersectionality, because this is a shared struggle of unfairness, a shared struggle of injustice. Now let's listen to Crenshaw. I shall get back by the end of the video, of course, where we shall also have a deep critical analysis. Let's dive in.
We've been talking about color blindness in and out of the day. And I want to talk about colorblindness largely as an ideological frame that does a certain kind of work. I call this a colorblind museum. I'm going to give you some snapshots of colorblindness as they have been articulated in the law throughout history. Now, our first question might be, what actually is colorblindness? And we've been talking about it throughout the day in several different ways. I want to provide more or less a schematic of colorblindness as it plays out in the law. So in the law, when we encounter colorblindness, we encounter it first as a theory of racial neutrality. The idea being that equality requires neutrality, and neutrality is constituted by being blind to race, by not acknowledging race, by not giving preference on the basis of race, or by not discriminating on the basis of race. So it is one theory of what racial equality is, which is racial neutrality. It is also thought to be the mediating principle of the 14th Amendment by almost a majority of the justices on the Supreme Court. Namely, if you ask what does the 14th Amendment require, 4 of our current justices will say the 14th Amendment requires colorblindness. Now that might not be necessarily controversial to you yet, but I hope by the time I get done, you will be aghast at my telling you that colorblindness is just about to become the mediating principle of the Constitution. It is also a social theory of race and racism. So to be colorblind as a response to race and racism, you have got to boil down racism to decisions based on the basis of race. And you have to have a definition of race, which is largely a static definition of race, right? Usually it's framed as skin color, as opposed to other ways one might think about race. One might think about race as the historicized vessels of racialized power. One might think of race as relational as opposed to simply skin color. So to boil down colorblindness into ignoring race, you have to have something static to ignore, right? It's somewhat like, don't think about elephants. You have to know what elephants are in order not to think about them, if you even thought you could think about something that you're not supposed to think about. So colorblindness performs this kind of mental gymnastics in the law, which of course is impossible to actually play out. Again, I hope I can prove that to you. Colorblindness also is used to denounce a certain kind of social policy. So you would know those social policies by the terms that they're used to frame them. So used to denounce something called preferential treatment, used to denounce affirmative action, even now used to denounce traditional kinds of anti-discrimination interventions. The idea being that all of these things are departures from some kind of neutral baseline. And when you depart from a neutral baseline, you are actually engaging in preferential treatment. What is neutral? Neutral is colorblind. What is not neutral? What is preferential? What is preferential is paying attention to race in order to do something, right? So colorblindness tells us what the neutral baseline is. And finally, colorblindness helps us define racial equality as symmetrical treatment. So if we've decided that race cannot be the basis for which any kind of social policy can be used to pursue, then essentially we're creating an idea that equality is achieved when we treat people in a symmetrical way. And so what I hope you'll be able to see in a second, that particular notion of equality is not new. It's over a century old, and it was actually a conception of equality that was used to undermine the first Reconstruction, and I will argue it is essentially doing the same thing now. So let me see if I can get through it in time for you to say absolutely right. We live in a time where many people have used the term post-racialism and have embraced the idea that what we witnessed was what I call a big event that marks the difference between some time in the past and the time now. Big eventism has often been used to distinguish between different kinds of racial moments. So the Civil War was a big event, around which some people said the nature of our racial society has been completely transformed by this big event. Right? So blacks might experience racial segregation after the Civil War, but that has nothing to do with slavery. That just has something to do with our cultural habits. So the big event of the Civil War, the big event of the 13th and 14th Amendment, were often used to deny the continuity of racial subordination, to say that it was about something other than what most black people knew it was actually about. So the election of Barack Obama is sometimes the big event that says the day before he was elected, maybe some of the stuff that was going on had something to do with race. But the day after he's elected, now we have gone into a post-racial moment. And everything that is underneath the idea of the glass ceiling being shattered suggests that there are no more excuses for African-American disparity anywhere else throughout society. So it's basically a big event argument that's used to say we are post-racial in the sense that we used to be racial, now we're beyond that. Now, one of the questions is, well, when people say post-racial, what exactly is the moment that we passed from that history in which, looking at the White House, we could say that was a product of racism, or looking at the Senate, or looking at who's in boardrooms, or looking at who's in prisons, or looking at who's homeless. When did we go through that moment where at one point we could see that it had something to do with racial antecedents, and now it has nothing to do with it at all? So it's a question to ask for definition about what we're assuming the current situation is with respect to the historical dimensions of racial inequality. Now, I'll just pause for a minute to say there are any number of ways in which we might think about post-racialism. We might think of it as just a subvariant of being a race society. Like when we say post-colonialism, we don't think that a post-colonial society is the exact opposite of a colonial society. We see it as a subvariant with certain dimensions of colonialism still playing out. We don't tend to hear people talking about post-racialism as a subvariant of a racial society. What people tend to do is try to talk about it as its opposite, as its denial. So I'm going to push an argument that what is being contested is the nature of what we mean when we say post-racial, and obviously I'm going to make an argument that post-racial is not mission accomplished. It is not the idea that we are all now working together, and it's not the idea that race no longer bears any particular definitional content for understanding how our society works. Now, what I will say is at issue is broad competition between two different competing ideologies about how to capture and whether to intervene in contemporary racial inequality. So I've got two quotes up here. One, the first one, frames the ongoing disparity in terms of a society in disrepair. Something that has to be fixed. The idea that something is owed that has not been realized. The idea that there's a continuing demand for some kind of intervention to shape, alter, redistribute racial goods in society and also racial harms. It is the idea of repair. Some would see it as the core idea of the idea of reparations, right? So there is a problem, and that problem is not natural. That problem is a problem around which some kind of expected policy is legitimate to try to dismantle. The second position is a direct repudiation of that idea of repair. It's an idea that nothing is owed, Nothing is lost. No one owes anyone anything. There are no debtors and there are no creditors. What we have is just American society. There may be huge disparities across American society. There may be racialized patterns of this disparity, but it's not the product of anything that has been constructed or anything around which a claim can be made for alteration or redistribution. Right? So those are the two competing frames. Does anyone recognize the source of either one of these frames? What's the first one? Martin Luther King. When? March on Washington. So some of you probably don't realize that this was something that Martin Luther King said at the March on Washington, probably because you've heard the endless loop of the one thing that we are all taught that he said, which was what? I had a dream that one day my children would be judged by the content of their character, not the color of their skin. So most people hear the colorblind evocation of that speech. That's what gets celebrated every year, and every February we hear it over and over. We don't hear the deep indictment of American society that he also delivered. In fact, for the most part, the speech was an indictment of the status quo. It was an indictment of the failure to make good of the promises of the Civil War, the 14th Amendment. It was a demand for immediate and effective intervention. This last part was the flourish at the end. But the flourish at the end has more or less served as the basic marker of Martin Luther King, when in fact there was this deep sense that this is a society in disrepair. What about the other quote? Who's that from? Okay, so I'm hearing some whispers. It's our good Justice Antonin Scalia. It is his response in a case having to do with affirmative action. I'll talk about it in a minute. But it's basically speaking back across 30 years to say nothing is owed. So the idea that affirmative action is predicated on the notion of institutions in disrepair, cities in disrepair, markets in disrepair, he's arguing that that's a false idea. Right? There is nothing owed. And here's the more important kick to what he's saying. It's one thing to say that you don't have a constitutional right that has to be acknowledged to repair. So essentially, one argument could be you cannot use the 14th Amendment to force cities to create affirmative action programs for contractors, for example. That's one possible argument. But Justice Scalia goes beyond that. In all of these cases having to do with affirmative action, essentially one institution has already said we might not have to do it, but we choose to do it. We choose to do it because we're responsive to the history. We choose to do it because we're responsive to the political process. We choose to do it because we're responsive to institutional actors who say we don't like our institutions to carry the signature of racial discrimination from the past. So they've chosen to do it. Justice Scalia and others on the Supreme Court are now saying you can't even choose to do it. We're going to insulate the status quo against even politically legitimate efforts to create these on-ramps into these institutions and to change the way they do business. So in a sense, this position is one that constitutionalizes the existing status quo. And when I say constitutionalizes, it means we cannot disrupt it without raising a question of constitutionality, without giving to plaintiffs who claim that being deprived of what one of my colleagues calls, it's all about diminished overrepresentation. So many of these institutions are highly disproportionate, in which white Americans have a disproportionate share of most of what's valuable. Affirmative action cases are largely about fights about the diminishment of that overrepresentation. It's still going to be overrepresented, but it's about the diminishment of it. this idea of constitutionalizing the status quo means that the Constitution stands with those who say, I'm injured because our overrepresentation has been diminished, right? So these are the two competing ideas, and colorblindness is at the center of it, largely because the idea is colorblindness requires us to be neutral with respect to the existing status quo. Now, colorblindness is introduced as the would-be victor of the 19th century. If the courts in the 19th century had just held up Justice Harlan's idea that our society is a colorblind society, then the argument is we wouldn't have had all these problems. So I want us to interrogate colorblindness when it was introduced, just to evaluate the extent to which it is true or not that had we simply adapted American society to a colorblind ideal, we would have escaped the history of segregation, we would have a different, more integrated and racially equitable society now. So when I teach Plessy versus Ferguson in my class, I like to ask people who these various characters are. On the right side, my right side, there's a picture of a segregated waiting room, and then there's this person. Who do you think this person is? This is a case about segregation. It's a case that establishes that segregation is constitutional. So you look at this guy, do you think he's the judge in the case? Is he Justice Brown? Is he Justice Harlan? Is he the conductor that apprehended Homer Plessy and threw him off the plane? Who do you think this guy is? How'd you know that? So it is Homer Plessy. And you know, we were just talking earlier about hypodescent. This is Homer Plessy's genealogy. Way, way, way up in the, I think it's the upper right-hand corner, there's a black person. Way, way up there. And everybody else in his lineage is legally white, right? This genealogy actually raises one of the questions that Homer was trying to make. He actually made two different arguments, but we only know the case for the second argument. The first argument was that this particular system of hypodescent in and of itself was a racial injury. So namely, he obviously has a lot more white blood in him than black. But that preponderance of white blood does not save him from being categorized as black. It's an asymmetrical racial system, right? So you can't find somebody who has the opposite and basically say they're white. If he had been, if all these other ancestors had been black and he had one great-great-grandmother, he wouldn't have been defined as white. So he's saying that there's an asymmetry in the racial system that has deprived him of something valuable. And that thing he's been deprived of is whiteness, right? So that was case number one. Argument number two was, however we are defined by race, to segregate people on the basis of this classification denies those who are defined as black of equal protection of the law. So now, the response to the first argument was, but you are not white. So because you're not white, you don't have standing to make the argument that you've not been defined as white, right? So essentially it's a circular argument. You can't make that argument because you don't have the standing to make that argument because the actual law has already defined you as not being white. So it's basically the court's refusal to engage in it. Now, I often ask people, if fairy godmother from the past comes forward and says, Homer Plessy, I'm going to bless you with one of your arguments. You just have to decide which one you want to win. You can either win the idea that the racial structure is itself asymmetrical and racist, so that you and people like you can actually make a claim for whiteness that the law will back up. Or do you want to win on the question of whatever the racial classification system is to create racial segregation in this particular social order is unequal under the 14th Amendment? And we have great debates about this, because a lot of people say, well, if you show the inherent asymmetry of the racial structure, then that is a fundamental blow to racism, so we should pull that one out. Right? And other people say, well, not necessarily, because there will still be people who are preponderance of the evidence would be black, and they will still be subject to racial segregation. And it's interesting, over the course of the years, we should dismantle the racial system line has won out over the however people are defined, we should not have segregation, largely because I think people buy the argument that the problem of race is acknowledging race, the problem of race is the one drop of blood rule, so if we just pull that string, it'll all unravel. And I simply say at the end, let us talk about Brazil. If we really think that removing, the juridical category of blackness or providing for greater fluidity in a racial system is actually going to eliminate racism. But I'll just talk about that afterwards if folks want to go there. The Plessy court ultimately decided that segregation was constitutional, but did it on a very curious argument. They said, it is true that the 14th Amendment did create the right to symmetrical treatment, and it created that right of symmetrical treatment as a right to civil equality. It did not create a right to social equality. So the question is, which side of the line did segregation fall on? Right? How do you know whether or not segregation actually violates the promise of civil equality or not? Well, the court said, look, if everyone is treated the same, then we have civil equality. Now, one might think, good, Plessy's going to win, because obviously you're not being treated the same if you're being forced to sit in a dirty, noisy, nasty car because you're black, but if you are white, you could sit in a better car. Not so quickly. The court said, of course everybody is treated the same. They're treated the same because they're being treated symmetrically. Whites can't sit in black cars, blacks can't sit in white cars. There's an equality in that, right? That's symmetrical. So all the state of Louisiana had to do was show, yes, we don't allow blacks to sit in white cars, we don't allow whites to sit in black cars. The court's good, got you, you're okay. Now, we all, by 20th century lights, look at that and say, how can anyone think that's symmetrical treatment when we know what segregation was actually about? It was all about the asymmetry of the message, the asymmetry of the experience, the symbol of it, the consequences of it. There were all these asymmetries that had everything to do with defining what segregation was about. So what did the court do with those asymmetries? They put them in the social realm. You can't do anything about those asymmetries. They're all social, right? So people are choosing to interpret segregation in a certain way. The court said, look, we're white. If the blacks take over the legislature and they create segregation, we certainly wouldn't feel that we are inferior because of it. So you should just choose to think differently. Right? If you think differently, you have your solution. Like click your heels 3 times and you'll be in, the racial promised land. The second thing the court said was, look, if we give Plessy this right to social equality, we're actually giving the group something they don't deserve. And that would create all kinds of problems. So what we have to do is just stand back and let the whole thing work itself out in the racial marketplace. Eventually, African Americans might show themselves to be worthy. Eventually, they might be able to pull themselves up by their bootstraps. But we can't give it to them because that would be giving them preferential treatment. We can't give them something that they don't deserve. Right? So this court was under the view that segregation was a transparent social system that didn't already create the outcomes that they said that they were standing by willingly neutral to let play out. In other words, the idea was that segregation itself did not actually shape the idea about racial value that people thought they were seeing. Right? Now, Justice Harlan comes in, people like to think that he's the hero of the story, saying, we should be colorblind. This is ridiculous. We shouldn't have a constitutional rule that permits the states to create segregation along with all the messages of inferiority that go along with it. So as far as he's concerned, the rule should be colorblindness. Now, folks have lifted this up as the constitutional theory that will save us all, the constitutional theory that will give us equality. But let's figure out what Justice Harlan said just before he said those great words about color blindness. He basically said, look, we got this, white people. We don't need this extra law to reinforce our superiority. We are the dominant race, and we will be for all time as long as we stick with the program. Right? We don't need this extra stuff. So his idea of colorblindness was not a corrective to racial subordination. It wasn't going against racial domination. It was perfectly consistent with it. It was more or less, we don't need overkill. And segregation is just overkill, and it's just in bad taste. We really don't need it, right? So this idea that people have that Harlan's notion of color blindness would save us, or it is somehow got deep bona fides in the idea of racial justice, is just not historically accurate from the point of view of Justice Harlan himself. Now, the question is, what is the contemporary consequence of Plessy? So I'll just say a couple of these notes. So today, the idea of colorblindness in many ways replicates the symmetrical notion of Plessy and Justice Harlan's colorblind ideal. Let's go back to that affirmative action case that I was just talking about with Justice Scalia. It was a case of Richmond versus Croson. Many of you know it. Richmond, cradle of the Confederacy, a city that was no stranger to the Supreme Court. It had been before the Supreme Court for housing discrimination, voting discrimination. They closed their school system rather than integrate after Brown. That's how hardcore Richmond was, right? So now the issue was in a city that was nearly 50% black, less than 1% of all of the state's contracting dollars went to minority businesses. So when the city council became a more fully representative council, they held hearings and decided that they would create a set-aside program. So some percentage of the subcontracts would go to minority businesses. The main contracting association, of course, sued, and this case went up to the Supreme Court. And the question was whether this kind of intervention was constitutional or not. And the response was, equal protection requires symmetrical treatment. Symmetrical treatment now means colorblindness. So this is unconstitutional because the distribution scheme is not colorblind, right? So once again, you might say, well, what about all the asymmetries that we're talking about? Some of them, the same asymmetries that we were talking about in Plessy, namely who has access to contracting, the consequence of industrial lockout, the consequence of a whole history of individuals not having access to contracting because contracting is basically an old boys kind of process. What about all those asymmetries? And the answer there is the same as the answer in Plessy. They're societal. You can't redistribute societal value, no matter how much it's tied to racism of the past, no matter how many people you can point to that didn't have a chance of being a minority business. In fact, the reason why Justice O'Connor gave for not being able to sustain affirmative action is we have no idea how many minority businesses there would have been had there not been past discrimination. The whole point of affirmative action was to actually create the opportunities for those minority businesses to come into being. And that's precisely why Justice O'Connor said said, we cannot have it because you can't even show us any people who were actually discriminated against. So what I'm trying to suggest here is the same kind of symmetrical treatment that we now think is silly, namely black sitting in one car, white sitting in another, is actually being reproduced today in color blindness. A silly idea that race is basically skin color rather than social relationships, historically situated patterns of access. That is seen as being societal, and to actually try to redistribute that is seen as violating the Constitution. Now, in case you think that that doesn't go far enough, let me just throw this last little bit at you. This idea of color blindness was basically used to say that Linda Brown, who was the plaintiff in Brown versus Board of Education, was basically being harmed in exactly the same way as the students that she walked by on her way to school, right? Because all of them were subject to classification in determining what school they went to. So all of the information about what racial segregation did, all of the ways that it created an asymmetrical system, have now been washed out of Supreme Court doctrine. And the only injury is the injury of being assigned to school because of your race. Not being assigned a subordinate position because of your race, not for being that group that no one wants to be in school with because of their race, not the long-term social consequences of being a group of people who are pariah class. None of that has anything to do in terms of these four justices with what the actual injury was in Brown versus Board of Education. Right. So as Justice Roberts says, there's a solution to race discrimination. Basically, just put your race sunglasses on. You don't have to see it anymore. And if you don't see it, it's not a problem. Now, I want to say just a few words about education and then move to the last part of my conversation with you. University of California versus Bakke, one of the major cases that played a role in pushing back a broader social vision that was possible. University of California had an affirmative action program. 16 seats were set aside for students of color to compete. I do want to say this. A lot of times, Bakke gets talked about as a case having to do with black students. In fact, there are very few black students in the program. This is California. Right, so the majority of those students were not black. There were some blacks, but they were Latinos, they were Asian Americans, some Native Americans, and some African Americans. But it gets framed as a black race case for reasons that I'll suggest in a second. So University of California offered 4 justifications. You can see them. Interestingly, look at what is in common with the first 3 justifications and what's different about the last one. Right? All the first 3 justifications have to do with the consequences of segregation and the history of racial domination. They have to do with elevating the interests and needs of communities of color. The last one is about the university's interests, right? The university's educational interests, corporate interests, however you want to frame it. In the decision that circulates now as the decision of Bakke, all those first 3 justifications were removed as legitimate rationales for affirmative action. So anything having to do with repair is outside of the justification that the Supreme Court upheld. The one that they did address and embrace was the interests of the institution, right? So I think we heard earlier this morning that basically diversity says we will bring students in so that the university experience is more educationally valuable for everybody. Not really everybody. It's for the folks who wouldn't have been exposed to students if there hadn't been an affirmative action program. So what's the consequence of an affirmative action program that's not rationalized based on the actual interests of the community, but instead rationalized on notions of diversity? Well, there are any number of negative outcomes, but the most significant one is that it preserves the idea that affirmative action is a preference. It preserves the idea that the students are, by some measure, less qualified, and it preserves the idea that the existing ways in which institutions are functioning are not necessarily problematic. So we kind of see the consequence of that in many of the affirmative action cases that are debated now. Because affirmative action is not a right, it's something that universities can do. States can remove the ability to actually pursue affirmative action. So that's what happened in California. That's what happened in Michigan. That's what happened in Washington. Voters decided to repeal the capacity of universities to actually engage in affirmative action. Some will say that affirmative action is an unjustified preference. I want us to just do a quick thought experiment to see whether it is a preference or something else. If you look at all the different things that the University of Michigan, one of the key states that had an affirmative action program, gave people credit for, you will see that the vast majority of points that were available in the admissions system were wildly maldistributed on the basis of race. Right? So that was a built-in preference in the admission system. So you see you could get 28 points generally on criteria that largely were distributed to white people and maldistributed to people of color. So 20 points were made available for those who were people of color. So the question is not whether the admissions regime was a preference. The question was it too little to offset the preferences that were actually built into the system in the first place, right? So again, the whole fight over diminished overrepresentation, now the whole fight over do these few points actually fully offset the extent to which race is built into the very admission system.
So guys, after clearly listening to Professor Kimberly Crenshaw, here is my deep critical analysis, as I promised. You see, Kimberly Crenshaw is a law professor and a civil rights thinker. In her famous speech, The Agency of Intersectionality, she tells the story of how black women are invisible. I explained this part at the beginning of the video. And so, Kimberly Crenshaw, you know, it's not every day you meet people called Kimberly. So she tells the story of intersectionality. When black people talk about racism, she explains, they often focus on black men. When they talk about sexism, they often focus on white women. Black women who face both at the same time are often left out of the picture. See, Kimberly goes ahead to tell us that she proved her point of black women being left out by asking her own audience to name the names of black men killed by police. Many could do it very quickly. Then she asked for the names of black women killed by police. Very few people could answer. This silence showed how society often forgets black women who suffer from violence and discrimination. Crenshaw uses the word intersectionality to describe this. Imagine roads crossing one another. At the intersection, you get hit by traffic coming from different directions, north, east, southwest, right? You can get hit by traffic coming from different directions, I repeat. In the same way, a black woman can be hit by racism from one side and sexism from another. If we only look at one road, only race or gender, we will miss the whole picture of what is happening. Dr. Kimberly, Professor Kimberly Crenshaw, also shared a court case that shows the problem. It was called the Granfield versus General Motors. A group of black women, I repeat, said the company was hiring policies were unfair to them. The judge said they could not complain as both black people and as women. He only looked at gender or race separately. not together. Because the company hired black men and white women, the court decided there was no discrimination. This ignored the fact that black women still suffered because they faced both kinds of unfairness at once. Kimberly Crenshaw's message is still important today because black Americans, especially black women, still face many problems that come from overlapping discrimination. We have examples of this problem. First is police violence. The deaths of George Floyd and Tyra Nichols are well known, but the deaths of Breonna Taylor, Sandra Bland, and Michelle Cocox are not spoken as much. This is why Crenshaw started the hashtag Say Her Name campaign to make sure the world remembers these women and understand the injustice they faced, right? Intersectionality, come to think of it again. So Crenshaw does not want us to separate the evils of racism and the evils of gender and sexism, right? Remember, she has explained using a case between some group of people and General Motors. So this group of women are saying that the hiring methods of General Motors is not effective, is biased, right? And the judge says, it's okay, we have black men over there. Why are you complaining? We have equality, but not equality towards women, as told by Kimberly Crenshaw. Kimberly Crenshaw does not want us to separate race and sexism. No, he doesn't want us to do that. He wants us to put it together and see it as a whole, right? Take for instance, this chair I'm sitting on, right? Or let's use a car. A car has different parts that makes it one, right? So if I remove a tire, the tire of a car, the one which rotates on the ground, the rubber, if I remove it, you see, the car cannot move. The tire itself is not important. Actually, a kid can take it and play with it. But it's of a very, very great value when it matches to where it's supposed to be, right? So, in the totality of reality, everything makes sense. But in separation, they do not make any sense, right? This is how I am understanding Dr. Crenshaw Kimberly. Now let's continue. So after discussing police and violence, where we mostly know of the male black victims, we don't know of the black female victims. Sorry, I did not arrange in the syntactic, I did not follow the syntactic rule of the descriptive words. We call them adjectives, right? So let's look at the other aspect after explaining police violence. Kimberly explains it in terms of jobs and money. Many black women work in long-paying jobs, such as hospitals, shops, or as domestic workers. These jobs often have no benefit and little protection. When COVID-19 came, for instance, these women faced the highest risk of getting sick and losing income, right? The third instance is health problems. Black women in America are more likely to die during pregnancy than white women. That's true. They are also more likely to face doctors who do not believe their pain or take their health concerns seriously. These are problems that come from both racial and gender bias working together as a unit, but we tend to separate them. We also have the pay gaps. Dr. Kimberly Crenshaw explains that black women are less than white men and even less than white women for the same kind of work. This shows that fixing the gender gap pay or the gender pay gap without looking at race will not help anyone, everyone I mean, equally. Another one is the school and the justice system. Dr. Crenshaw Kimberly tells us black girls are more likely to be punished harshly in schools. They are often suspended or even arrested for small problems that white girls would be forgiven for. This early punishment comments or connects to larger patterns of over-policing in their communities. Dr. Crenshaw teaches that to fix these problems, we need to see the full picture first, and that means making laws and policies that look at both race and gender as a unit together, I mean. Another thing that Dr. Crenshaw Kimberly advocates for is listening to the stories of people who are affected by more than one kind of injustice. Another one is collecting data that shows how race and gender combine to create special problems. Another curative purpose that Kimberly is giving is building movements that include everyone, not just the most visible groups, right? The words of Kimberly Crenshaw are not just for lawyers or activists, they are for all of us. If we want a fair and just America, we must learn to see who is being left out of our conversation and our solutions. Intersectionality, as she explains, is like putting on the right pair of glasses. Without them, everything looks blurry and we miss the details. With them, we can see clearly who needs help and we can join together to make changes that include everyone. Yes, as the earlier proverb said, a spider's web is weak if it stands alone, but many webs together can stop even the strongest forces, right? If we weave our fight as black people for justice together, connecting the struggles of race, gender, and inequality, we can build a future where no one is invisible. Yes. So guys, that was Dr. Crenshaw Kimberly. She has introduced a new concept. I never knew about this. It's called intersectionality, right? The intersectionality, which basically means that we should look at race and gender as a single problem, but not different ones. We might be trying to confine, or rather we might be trying to discuss racism, to discuss sexism, but we fail to notice that they are a unit. In the totality of reality, everything makes a sense, as told by Dr. Crenshaw Kimberly. Yes, this is EFK Original Documentaries. You like what I do, subscribe. I'll surely appreciate for your subscription. Support me on Patreon. If you like my work, please do. I'll surely appreciate. And thank you so much for my members. I really appreciate. I'll buy you a cake and we shall eat it together. Yes, as a unit. Yeah. So thanks for watching. This is EFK Original Documentaries. Support me on Patreon. You can send me something on Patreon as well, or super thanks. Still appreciate. See you in the next one.